Welcome back to the Tortoise Climate Summit. We're here for the first session to talk about how we can fight climate change in the courtroom, and how the overarching theme of the day is to think about the climate transition and whether making this transition fairer will also make it faster. The courts are a place to think about the question of who pays, who's responsible, and how we apportion blame. And they've increasingly become a space in which we make these decisions, in which this is being fought out at present. I'm being joined by Maria-Krystyna Duval of Client Earth, and hello, Maria-Krystyna, and Eugene Linden, the investigative journalist. Maria-Krystyna, I'd like to come to you first to give us a sense of where we are on climate and the courts. And the law is obviously kind of really growing in importance here. And one significant case is the Milieu Defensie case against Shell in the Netherlands, where the judges in that case said that Royal Dutch Shell had a legal duty to make deeper cuts to emissions than they had planned. And this case has really been a sort of shift in the way we think about corporate responsibility, not just thinking about damages for past actions, but thinking about the present and the future. I'd like to come back to that in the conversation. But there are also cases that we might think about as trying to preserve the status quo, or perhaps an anti-climate cases. And there's a session coming up later today on West Virginia versus EPA, which is one such case. But Maria-Krystyna, if I can start with you, and a very broad question. What's the purpose of the legal action that we're seeing at the moment? Is this aimed at bringing about kind of broad shifts in behavior, or is it more narrowly about winning redress for specific harms? Where are we in terms of legal action on climate?
Good afternoon. I mean, I think to answer the last part of your question, I think that what we're looking at the moment is both. And that's a Client Earth and other NGOs that are bringing some of these claims, because I think in certain cases, it really is to address a specific harm. For instance, the case that we are bringing before the United Nations Human Rights Council on behalf of Torres Strait Islanders is really to highlight the fact that people who live on these islands that are on the northeastern shores of Australia are already suffering from the effects of climate change with sea level rise and severe weather events. In other cases, though, what is trying to be achieved through the courts, and it's essentially because it's not being achieved elsewhere at the moment, is really to see a shift in the law and a shift of where the liability rests, whether that is with governments, and that's really the point of Shell's case, but also the case that was won last year in Germany, but also against directors of companies who up until now have not successfully been held liable for the mismanagement of climate risks. And I also saw in the chat that somebody was asking about greenwashing. I mean, I think another really essential trend at the moment is to establish that misleading consumers on the climate impacts of a company like Total, like Exxon, is also something that is should no longer be acceptable under the law. So I think that there are two things going on. One, to highlight specific harm, but another one, which is to see systemic change brought through the courts, but really to the legal systems that govern our behaviors, both in the public and the private sector.
Thank you, Maria-Krystyna. I'd like to pick up on that last point that was made about the shift in behavior, and turn to you, Eugene Linden. Eugene, you're the author of Fire and Flood, A People's History of Climate Change. Could you give us some of the broader context to this? Do you think that this shift to legal action that we're seeing is happening because of frustration with the diplomatic process, because there's been a sort of breakdown of the international cooperation we need? Or do you see this as more of a sort of companion to climate diplomacy? Is this something that is a sort of parallel track?
A little of both, actually. One, broadly shared frustration is absolutely felt by anybody who's been concerned with the issue. I've been writing about it since 1988, and I remember in the 90s, people were talking about suing Exxon, and that Exxon, I think, accounted for 1% of global emissions, and thereby you had a sort of metric by which you could establish some sort of liability. Of course, that is still ongoing in the courts, and for very different reasons. So I think the frustration has been there from the beginning. The idea of legal action has been there from the beginning. And people have good cause to be frustrated with the international process, since the first efforts to attack climate change at the international level began in the early 90s. Emissions are now 60% higher. There's 2.5 billion more people emitting an average of 4 metric tons a year of CO2. So the bogey is that much bigger. And of course, so it's more of a sense of urgency right now. I wanted to say one thing about the utility of these lawsuits, and that is that I think you touched on it. It's at the director level. You have what's called D&O insurance, director and officer insurance, that insulate the directors against suits. Well, I think beginning in the late 90s, some reinsurers have set up exclusions where if your company is a bad actor in climate, gets sued, you're not protected by D&O insurance. That gets the attention of directors because no director wants to be insured. Now, in these cases, of course, the company or the director's backer will indemnify them on this case, but that's not nearly as certain a protection against liability as D&O insurance, which will protect you. And so I think that as these suits progress and get more traction in the courts, more and more directors are going to find themselves exposed and without D&O insurance, and that is going to have a profound effect on behavior, corporate behavior.
Okay, that's a really interesting point that I'd like to come back to with Maria-Krystyna. But before I do, I just want to think about this at a country level. Maria-Krystyna spoke about the Torres Strait Islanders. Obviously, the climate crisis is now with us for many people in the world. It's an existential threat to a lot of people in the world. Could you just expand on the case that's happening with the Torres Strait Islanders, and also tell us a bit more about how this feeds into the connection with climate diplomacy? So is this a case where people who are living in the Pacific are just fed up with the diplomatic process and are saying this is our avenue now for seeking redress in this case? We seem to be having some technical difficulties with Maria-Krystyna, so let's go to Eugene on that question. Eugene, do you think it's the case that countries are simply fed up here, and that this is going to be the path now for this the battles that we've seen playing out at COP between developed and less developed nations to play out, that this will now shift to the courtroom rather than international convention centers?
Yeah, I think that probably will be the case. I do think that ad hoc and piecemeal, which in a way is what we've got, is not the way to go. Can I put this in a broader context? If we look at the negotiations, what is it, COP 26 of these things, and we've gotten basically nowhere. Emissions are still rising, and we face apocalyptic is not too strong a word, future, unless we get reductions in emissions, not just zero growth. And clearly what has happened is that complexity is the enemy of action, because it invites endless negotiation, which is what we have. People have tried to fine-tune things, and that gives wonderful opportunities for bad actors who want to delay is, of course, what they really want and have wanted from the beginning. And so I think there has to be a couple of tracks here. One is, I think in the absence of international action, of course, there are going to be a lot of suits at the national level. But at the same time, it ought to be an impetus for international action, because for instance, the EU talks about climate tariffs. Now I've been advocating for these things forever, but my argument is they have to be universal, because otherwise you get comparative advantage, you get people misusing them to achieve trade advantage and things like that. And so things have to be universal. So I came up with like 3 design features for any international action. One is it has to be simple, because complexity invites endless negotiations, which is what we've seen. 2, it has to be universal, because if there are exemptions, we have what we got, where China rose from having literally half the emissions of the United States to double the emissions, and now accounts for more emissions than the EU and the G20 combined. But third, it has to be immediately deployable. Because if we have to design something, we're another 5-10 years down the road and we're ever closer to these tipping points, and we don't want to get to these tipping points. And one little thing about back in the 90s, the tipping points were seen to be at 5 degrees Celsius. Now they are believed to be 2 degrees for a few of these things, and that's very close to where we are now. In any case, we have to do something now. So if we could get something universal going, it would take away some of the impetus behind all these national suits, but I do agree are going to become more frequent just out of frustration with the lack of international action.
Thank you, Eugene. So I think we've fixed the technical issue we were having, and we'd like to come back to Maria-Krystyna now, please, and to come back on that question of the Pacific Islands and whether there's a template for future action.
Yes, so I think I would say probably two things. I mean, one, to begin with, I want to make very clear that what has been agreed at an international level, especially in the body of the Paris Agreement, has only in a handful of states been brought into national laws, i.e. having actual net zero emissions by 2050. And so that means that the enforceability of those international agreements is not on the same level as that of national laws. So that's one thing. And that means that in that handful of countries where those national laws have been adopted, they can be challenged within that national jurisdiction before the courts of that country. Now, in countries where no such laws have been adopted, and it may be no surprise that Australia is one of them, citizens who are suffering from the harms of climate change have to find other mechanisms to defend their rights. And that's absolutely what's happening with the Torres Strait Islanders. It's also what's happening in Poland and other countries where suits are being brought against national governments. And there, what is being done is that it's the use of human rights conventions at the international level, and often as they are transposed into national law, which are being used to uphold a right to a healthy environment, for instance, to say that actually, or using the right to life. So what citizens are trying to do, and I think this is almost parallel to what may be going on at the international level, which obviously is not going fast enough, as Eugene has highlighted, and there's immense frustration with that. But action is not also happening at the national level, where in fact it could. I mean, the Australian government today could decide to take unilateral action to stop mining in the country, but it is not. And it is not actually today being required by its citizens to do so, because they are actually in great numbers voting in governments who just do not have climate action as a priority. So citizens are turning to different mechanisms, different legal mechanisms, and using human rights as a means of establishing the rights that they have, and also as a means of recourses against their national governments. So I think that's what we're seeing happen alongside the other things that I alluded to before, which are the types of behaviors that we want to see in the private sector from directors of companies, and starting to hold them liable because they've really escaped any liability up until now. I don't mean even financial, I mean just purely in terms of their duties and obligations under current legislation to actually manage the climate risk that they're responsible for at the company level.
Is it possible that that companies could be held responsible, or do you think the cases that are more likely to be successful at a corporate level are going to be focused on individuals within companies?
Well, I think it's very powerful to go against the board of directors. The board of directors owe fiduciary duties to the companies. That's, enshrined in different ways in laws across the world. At the moment, we have gone public on the fact that we are suing the board of directors of Shell in the United Kingdom, and that's under the Companies Act, but you could imagine similar suits in other countries. I think it is only if those directors who have, the responsibility for the management of the company and its trajectory to net zero, only if they are held responsible for managing that climate risk, do I think that we will see very, very powerful shifts and changes in the private sector. I think until that happens, we will continue probably to see a certain degree of immobility, which is what we are seeing today. And by that, I mean, I've just mentioned Shell, but I should say that this applies to a broad suite of companies, not only fossil fuel majors, but companies in a lot of other sectors where this is a problem as well.
And of course, the point that you just made is that it's not just about outcomes in court, it's about outcomes in the real world. So do you think that the courts are really a way of reshaping behavior, of making companies change what they're doing?
Yes, we do. And that at several levels. For instance, I can give you an example of another court case that we're involved in Antwerp, where a company called Ineos is building one of the largest plastics factories in the world. And we were able in 2020 to block at least half of the project. Those proceedings are ongoing because they have been given the permit to go ahead. So we will continue to target that. Now that sort of targets the company on one particular project, but you can imagine that with those kinds of wins in the courts, projects will be canceled. And in fact, we saw that we sued Drax in the United Kingdom because we sued a decision from the British government to allow Drax to build a new plant in North Yorkshire. And as a result of the court case, we saw the company change its plans, and it has actually completely canceled the project. But that's sort of on a project by project basis. But you can imagine that an accumulation of those could actually drive a change in behavior at the company level. But more broadly as well, for instance, with the example of Shell and potentially other lawsuits, there's a potential for a real change in the law where essentially the courts order a company, as in Shell in the Netherlands, from a different perspective and for different reasons, but the company has been ordered to change its transition plan and its emissions trajectories for the foreseeable future. So if we start seeing court cases like that being won around the world, that will change behavior of directors of companies who will understand that they're being under an increased amount of scrutiny. I also do hope to see in the years to come, and we are pushing actively for this, as well as many others, regulators, even before you go to the courts, but regulators seeking enforcement of inadequate climate disclosures, for instance, or the information that is given by companies. I think regulators have an incredibly powerful role to play, especially when it comes to listed companies and the information that they are obligated to give the market.
And there is a strand of climate litigation that relates directly to this disclosure, isn't there? Which has a parallel perhaps with the litigation that was brought against Big Tobacco. You presumably have been following that strand, Maria-Krystyna. Could you tell us a bit more about that?
About climate disclosures in particular?
Exactly, and about what it is that the people bringing these cases are seeking to disclose or seeking to have brought out into the open.
Yes, I mean, I think essentially there are a number of these cases, but essentially what they're trying to bring about is the fact that a lot of the critical information that needs to be used and looked at by companies in order to make decisions is actually not even being considered at the corporate level and at the company level. And I mean, and that's being done, across the board. Like we know about some of these cases because they have been brought to court. But if you look at, and we've done this exercise in the UK, but if you look at many, many annual reports of large listed companies, including those that are high emitters, there's very little decision-making important information in there for investors today. Now, obviously, as you can imagine, if investors are unable to use the information that is published by companies that they are invested in, that creates an incredibly important systemic risk for all of us, for us as an economy, because that means that investors like pension funds who are investing for the long term are unable to make decisions in terms of where they put their money. And here we're talking about, trillions and trillions and trillions of dollars. So something that could have, as an effect, economic impact and economic shocks across the world. So I think we will see more and more of those. I mean, what we're also seeing, which is encouraging to a certain extent, is a recognition, at least by regulators, that they have a role to play in this transition. I think the question is how much of that is being actually enforced by regulators. And I would also say how much simply capacity do regulators have to meaningfully look at these company disclosures and interrogate them. Our sense is at the moment that regulators do not have enough of that capacity in order to do that job in a meaningful manner. And we should all be worried about that.
Eugene, I'd like to come to you on this point about corporate disclosures, what companies know and what is coming out in court cases about their awareness of climate change. I mean, this is something that you've followed, and I think you're also familiar with the parallels with Big Tobacco. Could you give us a sense of how this is currently playing out?
Well, the largest parallel with Big Tobacco, I think, is that for years, people were suing Big Tobacco and losing and losing and losing. Then they started winning cases and the floodgates opened. And I liked your chart that you put up earlier where you showed the ramp up in terms of cases. And as cases begin to be won, the floodgates may be opening. This will definitely capture the attention of the C-suite and the top of corporations. And I think in terms of disclosures, yes, a lot of people are aware that for one thing, their general counsels are going to be telling them, even if they're insulated from anything else, because you look at every risk factor, and that's certainly one of them. And as climate litigation becomes a risk, of course, it's going to drive it right to the attention of the top, and that's nothing but good. And I think as a result, what we're seeing today, which is fascinating, is this enormous transition for most of the climate era, which I date to 1988. Corporations saw climate change regulation as a threat to profits. And then they were incredibly effective in delaying action. And one of the reasons we haven't taken it any is they've successfully muddied the waters so that the public has never really gotten the sense of alarm that's shared by the scientists, which is really remarkable because, I mean, with just as a brief digression, with COVID, it's the opposite. The scientists are alarmed and the public is far more sanguine about the disease. But with climate change, that's been one of the problems. There's another problem I'll get to in a second, but what we see in this transition in corporate behavior is really fundamental, because now, after seeing regulation as a threat to profits, they're realizing certainly in the multinational and the larger corporations that climate change itself is a threat to profits, but also they're seeing that the action on being on the wrong side of this issue is an existential threat to a lot of corporations. So that's changing behavior. And we're in the midst of this fascinating transition where many large corporations, part of the corporation is still joining organizations like ALEC in the United States, which is an organization to fight any type of environmental regulation or regulation of any sort. And other parts of the corporation are joining renewable energy lobbying groups. So one part of the corporation is actually lobbying against another part of the corporation. And that's with one of the largest renewable users in the United States, which also uses natural gas. So you have this really fascinating dynamic going on. I do think that until incentives are changed at the retail level, business as usual still has powerful momentum, and that is still going to be a problem. But this transition that you've talked about is happening. We have to encourage it as much as possible, and I do think the suits, and particularly on disclosure and just making disclosure an important part of corporate life at the top level, is really going to hasten that transition.
Eugene, there are a couple of questions in the chat that I'd like to pick up and think about. One in particular on companies is a really interesting point about the number of state-owned fossil fuel companies. They're obviously not vulnerable to investor pressure. Are they vulnerable to litigation in the same way that publicly owned Western oil majors are? And what are the differences here?
Well, in the States, I think there are some suits against the government. Someone else on the panel or in the audience can probably fill that out. So I imagine it is entirely possible to sue a state-owned entity. I do think that at the state level, treaties become important rather than litigation. And that's why I think, litigation, to go back to the beginning of this conversation, is a response to the frustration of the inability of anybody to come up with a treaty that actually has some impact. That what will happen, going back to this transition and trying to link it to what you're talking about, is that if piecemeal legal action becomes ever more prevalent, the reaction of large corporations is going to seek regulation or to seek a treaty, because they'd much rather have uniformity than death by 1,000 cuts. And we saw that when Trump tried to roll back the fuel emission standards in the United States. The big automakers weren't on board, most of them, because they wanted uniformity. They didn't want to have to build a car for California and a car for the rest of the United States. So what we will see is, as these suits proliferate and begin to gain traction, there will be a movement in the business community that will actually be pro-regulatory and pro-treaty just for uniformity of just to have a level playing field that they deal with.
Maria-Krystyna, just thinking about this question of how companies respond, is there a risk that climate litigation becomes something that is essentially an instrument that is more open to wealthier countries, because less developed countries will have fewer resources compared to the multinationals that they're trying to pursue, and it becomes difficult for them to say, well, come and invest in my country if they're opening themselves up to legal risks. So does this become an unequal way of pursuing this question?
I would say that most of the companies that are doing the damage at the, let's say, at a global scale, are companies that are headquartered in only a handful of regions of the world, and very much so, in North America and in Europe, increasingly in Asia, to be fair. So a good place for all kinds of reasons in terms of where the headquarters are and where one might have standing to actually bring the case. There is a good case to bring litigation against those companies in the states where they are incorporated or where they may have a lot of their assets. What is, however, happening outside of those regions in the world is that there are now an increasing number of cases, for instance, being brought against states for the fact that they're not protecting their citizens from the impacts of climate change. And it is not to be excluded that one of those, citizens in one of those countries, and this is where, international law mechanisms are fraught with complexity. And in terms of receiving one of these court cases in, let's say, in England or in the Netherlands, but it may be possible for a group of citizens outside, let's say, of Western Europe to sue a company before a European state court as well. So there are a variety of mechanisms that can be used to protect citizens in a lot of these non-European, let's say, non-North American countries from the effects and impacts of climate change. I mean, I would add, though, very practically speaking, and being in an NGO where we are doing this work, one does need funding in order to do it. There are costs involved with getting outside counsel, but also expert evidence. So while these cases are proliferating, I don't mean to say that it's an easy lift either. So you do have to have a certain amount of resources and the right types of experts to work with on the cases in order to persuade the court, essentially. So that is a limiting factor.
I'd like to come to someone who's posed an interesting question in the chat, and his name is Zainul Ali. Let's see if we can get him on screen to pose this question. Zainul, welcome. Would you like to put your interesting question to the panel, please?
Yeah, no. Of course, the reason why a lot of companies aren't following the climate goals is because money is an incentive for them to continue on ruining the planet. So my question is, what are possible alternative incentives for brands to continue doing their thing, but not ruining the environment at the same time? I guess money drives them to do it in the first place.
Yes, I think that's right. So I think maybe there are two aspects to your question. Thank you for posing it. I think one is how these companies, and this is very, very true for state-owned companies that we touched on before. One of the ways of going after state-owned companies, because it's true, many of the oil companies in the world are state-owned, is to look at where they receive their financing from. And so while we've talked today about attacking directors of corporates, there is also a big amount of work that can be done in terms of looking at the availability of financing from private and public financial institutions, as well as the debt capital markets. Because, for instance, a lot of these oil companies get funding from the debt markets. The other thing I would say, though, to your point, is that there is a question about how people are incentivized for their own pay packages, whether they are on the boards of directors or CEOs or in the C-suite of companies. And that is another aspect to this. At the moment, I don't really know, I think offhand, of any country that's legislated in order to reduce those pay packages when it comes to interrogating, for instance, the profits of companies, when it comes to looking at their forward-looking projections when it comes to profits. And something that sort of ties into this is audit reform. How these companies are audited and how their annual reports are signed off. And there's a host of complexities of issues with that as well, in terms of thinking about the time horizons that auditors look at when they look at what companies are publishing about their information and their forecasts. But you're right. I think money and incentives are the nub of the issue in a lot of cases, and there's still, outside of the courtroom, there is still much to be done with the law more generally about changing some of these incentives by changing legislation, essentially.
Eugene, I'd like to come to you on a question that has come up in the chat and is also particularly interesting about whether the courts themselves could become seen as political players in this. I mean, the person who put this in the chat suggested, what if the courts themselves are biased on these questions? But I suppose there is a broader question of saying, the courts could be seen as becoming kind of political fora in this dispute. Is that a risk, and how might this change things?
It totally is a risk. Look at today. We have West Virginia suing EPA on its authority to regulate greenhouse gases. And if that goes to the Supreme Court, as the Supreme Court is currently constituted, I think there's a real danger that they will strip the EPA of its authority to regulate greenhouse gases, which will set the United States back by decades in terms of dealing with climate change. So absolutely, it's a risk. We've seen some lower court decisions that reek of politics in terms of climate change and other environmental issues. So yes, it's an issue that the danger from my point of view is not that the court's becoming too activist in terms of going demanding climate action of corporations and others. It's going in the opposite direction and basically saying the agencies are overstepping and they don't have the right to regulate these things.
So is it in the end the case that the courts don't offer us an option for bypassing the politics of this? There is no way to get to net zero except by winning the political argument?
Yeah, well, I mean, you have to use the courts, and of course, the courts are not a uniform thing. Different administrations here and abroad appoint different judges for different lengths of time, so it's not a unilateral thing. I think, of course, you have to use the courts. I do think that the worst thing that ever happened to climate change in the United States happened in the late 90s, and it was that the issue became politicized. To reference what you're talking about. When Kyoto went into effect, big corporations realized that, gee, maybe Kyoto isn't going to have an impact on us, but down the road something might. And they began a campaign sort of tying climate change action to a liberal agenda, which is ridiculous on the face of it, since climate change is a geophysical issue, not political issue. But it worked. And what we see is that once an issue becomes politicized, the messenger, if the messenger is deemed illegitimate, meaning on the wrong political side, facts don't matter. And so polling data shows enormous levels of ignorance in the United States about the sources of climate change, things like that, even in the last couple of years, or whether it'll even have an impact in their lifetime, because the issue has become politicized. And the analogy, of course, is COVID, which became politicized instantly. And all of a sudden, you saw the messengers like Fauci and others being demonized, and facts couldn't penetrate those who believed it was a hoax. Well, same thing happened with climate change. What will change that, in my view, and this has to do with litigation, is that the costs of climate change become undeniable. If you live at the coast, and you're getting king tide flooding and fair weather flooding and sea level rise threatening you, and storms and everything like that, doesn't matter whether you're a liberal or a conservative. If the price rises, it's going to catch your attention. If you're living in a fire zone in the West and you can't get fire insurance on your house, it's going to catch your attention. And if the litigation, of course, brings costs home to the corporations, that's not political either. And it's a matter of dollars and cents. So to refer back to the earlier question, as the costs of climate change begin to surface, they will more and more be integrated into this business decision making, and that'll have a healthy effect in terms of trying to recognize some of the things. The statistic that drives me nuts is that 90% of fossil fuel emissions go into the atmosphere with no cost attached to them whatsoever. So there's an enormous opportunity to actually bring some of those costs and distribute them at the source. I think one of the figures is there's something like 60 corporations that account for the majority of climate change emissions, greenhouse gas emissions in the world today. There's a target for you. And excuse me, that'll that could deliver real bang for the buck.
Maria-Krystyna, I'd like to pick up on the point about costs that Eugene just raised and bring it back also to the national level, and to ask you, so give us a sense of what's at stake here. I mean, are we going to get to a situation where nations might be asked to pay reparations to other nations or peoples for the damage and the loss that they're going to suffer? And is there any kind of precedent for this? I mean, what's this going to look like?
That is an incredibly interesting, but at the same time, I think a very difficult question. I mean, there are some, at the international level, there are negotiations going on about this. I think whether they ultimately result in a decision to pay for certain countries to pay other countries damages, I am not entirely convinced that we will actually see that happen in that way. But I'm not excluding that as a possibility. I think that what also might happen is there may be an increase of money that is given in order at the moment, for instance, for countries to actually combat the impacts of climate change. So, it will depend on the country, but for instance, constructing barriers against flooding or helping countries install things against extreme heat, which will be a major problem for a lot of transition and developing economies. I mean, today where it's becoming increasingly difficult for people to work. I think there may be other types of mechanisms like those, making that finance more available, while at the same time, hopefully, and this is, I mean, I am hopeful, despite everything that we've said today, that things are changing. I mean, I think that there's huge opportunity for us in the, let's say, the Northern Hemisphere to continue combating climate change so that we can reduce those impacts as much as possible. I mean, I do think, to go back to Eugene's point as well, a very powerful mechanism will be when insurance companies and states are actually put on the hook for some of these damages after a major wildfire. I mean, the insurance sector has an absolutely tremendous role to play in this. And obviously, because for them, affordability will become an issue. But interestingly enough, with them, they are paying the cost of climate change while also investing in major fossil fuel infrastructure. And at that, there will be a point in time when that's no longer a sustainable business model for them. So I think that as we start seeing, unfortunately, very unfortunately, the cost of climate change increase, corporates, but also for states, there will be an incentive to potentially, start alleviating and having more financial flows go towards those countries where people are suffering the most. But unfortunately, up until now, we've not seen those negotiations reach fruition. We're just not seeing the amounts of financial flows that need to be flowing from the north, let's say, to the south, to simplify matters.
Thank you, Maria-Krystyna. And you've touched on this earlier, but I just want to kind of pick up on something about the different legal strategies. You said there were different ways in which companies and nations are being pursued in the courts. Is there one legal strategy that's emerging as the prevalent or most popular, most effective one?
I mean, I think there are probably two main strands at the moment. And I would like to just make very clear as well that while today we're talking about litigation in the courts, we at ClientEarth firmly believe that it's the law broadly that can change the protection of the planet more broadly, actually, than climate change. So when we go to court, for instance, it's because in a lot of cases, a lot of our other efforts have actually not been successful or not sufficiently successful, because there's a huge amount of work that can be done pre-litigation, because as you can imagine, litigation involves costs and it involves risks. To go back, though, to your specific question, I think that there are two strands emerging at the moment. One is human rights, which I mentioned earlier on. So literally citizens and individuals taking, at the moment, mainly states to court. And I think that's a hugely powerful lever, because actually all citizens can identify with them in a relatively straightforward manner. So we're seeing that in a number of countries where citizens and young people especially are taking their governments to court. But there's also very, very, starting to emerge, taking corporations using essentially corporate and finance law and just using a different interpretation. This is often not regulation that was drafted with the environment in mind at all, but actually these obligations on directors to actually manage a company or manage a financial institution can, and that's what we're hoping, be read to include a right to disclose, but also to act and manage on climate and environmental risks. So I think there are these two strands that are emerging and accelerating in the courts around the world, predominantly in the North, as you've identified, but I also hope that we will see some of those cases emerge in other jurisdictions as well.
And Eugene, on the question of legal strategy, there's something interesting that you said earlier when you talked about big tobacco for many years winning cases or fending off cases, but then hitting a tipping point. What was it in strategic terms that changed there? And is there anything that we should look at that gives us a clue into where we are now?
I think in terms of tobacco, the iconic event were the 5 big tobacco people testifying in Congress and lying, just lying. And it had a profound impact on the zeitgeist, and so it wasn't an illegal situation. I can't remember what the first case was in tobacco, but once one case, gets decided, people gravitate. If it's seen as a losing strategy forever, that eventually the energy dies. But once you actually have a big win, and there were big wins, multi-billion-dollar wins, the legal incentives are to pursue this. So I do think, and I want to go back to something you raised earlier about whether poor nations will have the legal resources to sue. I think money is flowing into climate change, big time. And people look for opportunities to make a difference. John Doerr, the venture capitalist, just gave $1.1 billion to Stanford University, set up a climate center. Other people are funding. So if litigation looks like it's a promising way to represent the interests of the small island nations and other poor nations, money will be there and expertise will be there. I mean, yeah, it would be better if there was some funding mechanism, but in the absence of that, people look for a way to make a difference. And I think one of the big changes now is that, money is flowing into renewables, for instance, and that and flowing out of fossil fuels. It wasn't, at least until the Ukraine invasion. So these money flows will make a difference. It'll be money for litigation, it'll be money for renewables, it'll be money for innovation, and it'll have its impacts, and it already is having its impacts. Yeah, go ahead.
Thank you. I just we've got a few minutes left, and I just want to kind of pull together something that strikes me as really interesting from what you're both saying. So there's a point about responsibility and the way that companies feel responsible, and it seems to be shifting as a consequence of this litigation. And one of the points is the way that we've had this principle of the polluter paying, but we haven't really observed this principle in the case of climate change. And we've also had a sense that companies might create messes, but then they'll clean up those messes and move on. Whereas perhaps the litigation is making us think a bit more about companies' responsibility to the future and future generations and the world that we're creating together. Can I ask you both, Maria-Krystyna first, how do you think this current wave of climate litigation is going to change the way that the C-suite operates, is going to change the way that company directors think about what their businesses do?
I mean, we're doing it because we're hoping that it will fundamentally change behavior. I can't promise that will be in the next 6 months to a year. The truth is litigation can be incredibly lengthy, but we are hoping that alongside a few other things, I mean, maybe one thing I would like to highlight is that the EU is working on a directive on corporate sustainability due diligence, which would, in its current guise, also pose impose obligations on directors in terms of due diligence on broadly environmental and human rights risks. So I think that there are several things happening at the same time that could see corporate behavior in the next few years. I don't want to put a date on that, but fundamentally change when it comes to environmental damage.
Do you anticipate the same kind of shift, Eugene, and how do you see this playing out?
Corporations are fundamentally amoral, regardless of mission statements. They respond to incentives and disincentives. The incentive, of course, is to make money. The disincentive is to avoid expenses, and litigation has created an ever more important disincentive. And so what we will see is corporations react to that in a way that's positive for climate change. Whether it's reacting fast enough is another issue, but the direction is the right direction. And it is not because they are becoming more moral. It is because they see this as, one, climate change is a threat to business, and secondly, litigation and regulation and all these other things as a threat to profits.
So you say the idea of the B Corp corporate purpose, that's just hogwash. Absolutely.
I mean, I could cite chapter and verse, but that would be going on for the rest of the day on it.
Maria-Krystyna, I just want to come back to you for a last word, and that's to sort of look to the future and look to what we think the future areas are for litigation. So what do you think is the sort of frontier as far as climate litigation is concerned?
Can you hear me?
Yeah, we can.
The tech. It's really the frontier to me is if we are successful in having a court in a country recognize that directors are responsible for managing climate risk. I think that will really open the floodgate. I mean, what we haven't spoken about yet today, because it wasn't the subject of today's discussion, but I hope that we are soon going to see that when it comes to climate change. I think the next big frontier is biodiversity loss. Because if we fix climate change without averting biodiversity loss, our efforts today are actually not going to save the planet. And for us to live here in a comfortable manner, in a manner of speaking, although some of that is, we haven't been able to avert in time, we need to see that happen for climate change, but for a broader set of directors' duties when it comes to averting biodiversity loss as well. I think that's incredibly important.
Maria-Krystyna and Eugene, thank you both very much. Gripping session. We've got just about 10 minutes now before the next conversation, which is being led by my colleague Giles. Thank you very much.